What do you do if you get sued for something like a credit card and you look at the name and think, I've never done business with them? Well, hang on, I'll tell you. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. So it's 6 o'clock on a summer's evening. You've just had your dinner. You're sitting there drinking a glass of iced tea, just kind of trying to figure out what you might be wanting to do this weekend. And the next thing you know, you hear a knock on the door and your dog barks. So you go to the door, you open it up, and there's a sheriff standing there. Badge up here, gun down here, and in his hands, he has some paperwork. He hands the papers to you and says, "You've been served." And then he turns around and walks back to his car. And you look at the papers, and it says that you owe MasterCard $15,000 and you don't have a MasterCard One and you've never dealt with MasterCard before. Holy cow! What do you do? It's not at all uncommon for you to be sued on a debt with a company you've never done business with and don't know anything about. That's because credit card thieves and fraudsters have gotten a lot bolder and a lot smarter about how they go about stealing identities. And if you get your identity stolen, even though you don't know it's stolen, and someone signs up for a credit card in your name using your social security number and your credit history, technically you could be on the hook for that if you don't act and act quickly. The way our justice system works is that somebody makes an allegation and says you owe a debt. You have to come into court and say, no, I don't. And then, if you can't work it out and prove to the other guy's satisfaction that they've got the wrong guy, then you have to litigate it. And you may have to hire a lawyer to do that. One of the reasons that a lot of these companies have sold identity theft protection, which is not really identity theft protection, it's just identity theft notification, because there is no system that I'm aware of that can protect you from ever having this done. The reason that those exist is because it happens often on a daily basis all throughout the country. But here is the problem. If somebody takes your name and identity and gets a credit card and runs up a $10,000 bill and then quits paying on it, and they come after you, they are more than likely going to sue you for that debt. And if they sue you and you don't answer and defend it, you could wind up on the hook for that debt by virtue of the default judgment procedure. So it is absolutely vital that if you get hit with a debt from another credit card company that you've never done business, that you immediately notify them that that's not you, and you immediately go and file a motion to dismiss or an answer in the court where you have been served with this lawsuit. And you'll need an attorney to do that, or at least to do it well. You can sometimes defend yourself, but it isn't wise. The other guys have all of the tricks in the trade up their sleeve, and they will use all of them to get their money, even though it's not their money. And so you have to be careful. It's always a good idea to hire an attorney to handle it. Several years ago, I worked on a case for the Good Samaritan Center in Jefferson City. I was working on it at the time, long distance, with a coordinator up in Jefferson City. And this lovely woman had been divorced from somebody who was not a very lovely man. He had applied for a credit card on behalf of her. He had used his girlfriend's signature to sign the application, and he had taken out a huge line of credit Yeah, they'd gone on cruises, they'd taken vacations, they'd bought furniture from IKEA, all kinds of stuff. And then, because it wasn't in his name, it was in her name, he just quit paying on it. And as a result of that, they came after her. So we had to prove that she wasn't the one who was signing these things. And one of the real problems with all of these is that very, very few merchants actually keep the signed receipt that somebody writes their name on when somebody charges a meal or something at Target. They don't keep that. And a lot of times, if somebody pays by the little tap ID thing, you don't have to sign anything anyway. So it is very easy to impersonate someone on a credit card if they have the little tap ID thing, because it's not biometrically linked to the card. You just put it up on the little tapper and boom, you got the thing paid for. So there was a huge issue with being able to show any of the signatures. The bank couldn't produce any of the signatures, and the law firm that was representing the bank in this case basically told them, look, we can't proceed on this, and ultimately they dismissed the case. But if we hadn't shown up, if we had not argued the case and pushed back and made them prove what they said that they had as an allegation that this woman was responsible for this huge debt, she would probably have wound up having to pay that. And that's not the way the law is supposed to work. Now, we were very lucky in that instance because the credit card action was brought by a Missouri attorney from St. Louis who was with a reputable firm and who was representing the actual bank in that matter. A lot of times when somebody skips out on a debt, in other words, they're at 123 Main Street when they get the card, they immediately flee to some other jurisdiction, run up $10,000 or $15,000 on the card, and vanish. In that situation, what usually happens is the bank winds up selling that debt to a third-party collection agency. And these third-party collection agencies are ruthless. What they do is they just hold on to that debt. It'll be good for until the statute of limitations runs, which is usually somewhere between 3 and 5 years. And they'll wait and they'll see if somebody comes back and has an improvement in their lifestyle. And then just when they're getting their feet back together on the ground, boom, they hit them with a lawsuit. That's when somebody hasn't skipped out on a debt. When somebody has skipped out on a debt, they don't know that. They just go in and sue them. And most of the time, they hire what I call high volume law firms. The law firm will go into court with a stack of petitions. In Missouri, it's called a petition. In other states, it's sometimes called a complaint. But they'll go in with a stack of them, 40 or 50 at a time, that has all of these people who have absconded on debts. And they'll file these actions and they'll try to get service on the folks. If they can get service on them, then they'll get a default judgment. And if they have bank accounts or personal property, they can go out and seize it. But most of the time, they don't. They take advantage of the fact that the bank may have a debt here for $15,000, but they can probably buy that debt for somewhere around $500. And if they finally do track this person down and get their money, they've made a heck of a profit. So that's one of the problems that you have if you have been named in a lawsuit and you have absolutely no relationship with that company. You're going to have to go and defend it. You're going to have to hire a lawyer. I'm sorry. It is better if you hire a lawyer and don't try and do this yourself, because I'll give you a good example. Several years ago, I got hit with a subpoena from the law firm that was representing State Farm in another action. And we didn't have any documents that were responsive to the subpoena, but the guy who sent me the subpoena said, please make sure to file your objection to this subpoena within, I think he said 45 days. And I only had like 30 days to file it. So he was counting on me using that timeline and not the timeline from the rule. Fortunately, we read a lot of rules as lawyers, and I knew better. So the other law firm might very well tell you, look, you can take a month or so to get back to me on this, and we'll, that'll be fine. Now, notice he's not making a promise. He's just saying you can take a month. And indeed, you can take a month. But if you do, you're going to get hit with a default judgment. And yeah, you can probably get that default judgment set aside on the basis of fraud if you have some way to prove what the other guy said. But if you can't, then you're going to get stuck with this judgment. So you absolutely, in most cases, you have between 20 and 30 days to file an answer in court. You have to get an attorney and get an answer on file as quickly as you can so that they can't take a judgment against you. Now, filing an answer and then a motion to dismiss is a good idea for one reason in particular. And that is, if you've got 50 cases that you file on Monday and you get a bunch of answers with people saying, hey, I'm not going to pay you, you're going to have to prove it. You'll get your money when the jury says I owe it and when the Supreme Court says you can keep it. Well, now, instead of just going in and taking a default judgment or a consent judgment, which is the other thing that they do, they now have to work for it. And heavens, they don't want to work for it. So many times in that situation, they will simply dismiss and walk away and say, well, we're not, they're going to fight us on that. We don't have time to deal with that. We're not going to take that case. And they can do that too. They can always tell the plaintiff, the bank, or the third-party collector, we're not interested in litigating this claim because there are defenses to it. Again, why would you work harder than you needed to work? I mean, that's their approach to this, and it makes some logical sense. It just doesn't seem to me to make much ethical sense. It seems to me that you only take cases that you know are valid cases, and a lot of these just are not. So, at the bottom line is, if you get hit with a lawsuit for something you didn't do, and you're certain that you're not the party that's named here. In other words, it may have John Smith and your name may be John Smith, but it's not you. You have to take every step possible to get into court and contest it and show why. You can get out of the deal if you do that, but if you don't take action, if you don't hire a lawyer and contest it, then unfortunately, many, many times you're going to wind up paying. It's not fair. It's not right, but it happens. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.